will come to order. Without objection, the chair is authorized to declare recesses of the subcommittee at any time. We welcome everyone to this morning's hearing, which is on the title From Miranda to Glenn, a call for pretrial reform. It is well known that the Miranda Supreme Court case provided the well-known Miranda warning pre-trial to give any defendant the right to counsel and to not have statements used against them, but to be able to be forewarned of their rights. And the Gideon case, of course, was to allow for an appointment of a lawyer for indigent defendants who cannot pay, and to recognize the importance of counsel. Simple concepts for pretrial and the issue of justice in America. Before we begin, I would like to remind members that we've established an email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members might want to offer as part of our hearing today. If you'd like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. I would also ask all members to mute your microphones when you're not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. I will now recognize myself for an opening statement. And as I've earlier said, good morning. I believe this is an important hearing as a component of the justice system and as well the elements of the Constitution, particularly the Bill of Rights, that govern the rights of all persons that will have to appear before a court of law, particularly in this instance, in criminal proceedings. As I indicated earlier, Gideon and Miranda cases were significant cases to add to and enhance the justice system that is so much admired in many instances around the world. Although our system is not perfect, it is a system that is admired for its outreach and balance to ensure justice for those who appear before the court. That means that it is our important responsibility to ensure its near perfection and to recognize the balance between those who acted or alleged to have acted and those who have been impacted by those actions. The subcommittee convenes today to examine pretrial justice, perhaps the most crucial stage of the criminal justice process. Following arrest, interrogation, pretrial detention, and charging decisions all take place in the days immediately following arrest. From the outset, the pretrial process, indigent defendants are at a disadvantage, often without access to counsel, and they frequently find themselves detained pending arraignment. Law enforcement officers and prosecutors may exert disproportionate leverage during this period since they have access to the defendant and all the evidence. Each of the major procedural steps, arrest, determining pretrial detention, and pretrial discovery, implicate the constitutional rights of the accused, who are presumed innocent. We must recognize and address the fact that current practices disproportionately disadvantage people of color. The interrogation stage offers one of the first opportunities to solve crimes. It should be used in that capacity, but also currently includes practices that may imperil constitutional rights and undercut the fair administration of justice. Who are we in this nation if we cannot provide that fair assessment and implementation of justice? In recent years, the number of documented cases of people wrongfully convicted because of confessions to crimes they did not commit has steadily increased. The Innocent Project estimates that false confessions have contributed to 28% of the 375 post-conviction DNA exonerations in the United States, all of which involve cases of murder and/or sexual assault. In more than half of all cases in which the post-conviction DNA analysis cleared an innocent defendant, It has also identified the actual perpetrator. Remind the members that the DNA usage is only a recent phenomenon, and just take note of the fact of the many people that may have been falsely accused and falsely convicted and falsely serving time. Many of those fall disproportionately on minority communities, particularly African Americans. Research has shown that certain conditions and police interrogation tactics are psychologically potent, especially when used in excess, and that sometimes some types of suspects are particularly vulnerable. Let me be very clear. We want tools for our law enforcement to be able to bring those to justice who have perpetrated horrific crimes and actions against society. We realize that there has to be a justice system and a system to hold them accountable. But we want to do it in a way that our chief and guiding force, yes, is the word justice. One solution I propose in legislation is that all interviews and interrogations of felony suspects should be videotaped in their entirety from start to finish, without interruption, without loopholes or exception, and with a camera angle that focuses on both the suspect and the interrogator. Increasing transparency in this manner is essential for judges to determine voluntariness and coercion, and for juries to determine whether statements are reliable and the facts attributable to the suspect. Another issue for us to consider is the conditions under which children should be interrogated. Very, very serious and very much a concern. Children are vulnerable, which is why they are statistically overrepresented in false confession cases. Additionally, we must keep in mind the array of issues related to pretrial detention, a subject we will review in more detail in the future. We must also consider the question of which defendants are provided diversion or given a citation to appear in court. The current system produces disparately negative results for people of color and on its face favors the wealthy. Lastly, we also must review our aspects of the current system that discourage trial and favor plea agreements. The combination of a number of pretrial practices end up with the poor and people of color waiving their constitutional right to a trial and pleading guilty, sometimes to crimes they did not commit. As you can see, we have many important issues to review today, and members, throughout our time as members of this particular important subcommittee, because wrapped around this committee is the question of justice that involves lives of those who may have been impacted by the criminal acts or alleged criminal acts, and those who have been accused or falsely accused in terms of incarceration or loss of life through the justice system. Justice has to be real. I look forward to the witness testimony and the robust discussion that will follow. It is now my pleasure to recognize the ranking member of the subcommittee, the gentleman from Arizona, Mr. Biggs, for his opening statement.
Thank you, Madam Chair. Appreciate that. And I once again request that you schedule a hearing of the subcommittee to examine how the Biden administration's crisis along the southern border affects Homeland Security and public safety. Last week, all of the Republican members of the subcommittee, and including Ranking Member Jordan, sent you a letter requesting that you hold such a hearing. We haven't heard back yet, and I hope that we hear back soon, because we think that this subcommittee should hold a hearing as soon as possible to examine how the Biden administration's failure to secure the southern border has allowed transnational criminal organizations, smugglers, and drug traffickers to engage in criminal behavior and harm public safety. And I was just down at the border yesterday, Madam Chair, and while on the Arizona border, I learned of a group of 112 individuals who had surrendered to Border Patrol agents just a couple days ago. The oldest person in that group was 94 years old. And the youngest was just 4 years old, and that child was not traveling with parents, sibling, or grandparents, or in fact, any other relative or legal guardian. But that child had been placed in the hands of the dangerous cartels that traffic in human sex and drugs. And the majority of the people in that group of 112 averred that they had come because they felt they had been invited by President Joe Biden. And so we hope to have a hearing as soon as we possibly can. And today's hearing is very important. The subcommittee will examine the pretrial stage of the criminal justice process. As a former trial lawyer who defended hundreds of individuals and also engaged in prosecution activity as well, I can tell you this is an important topic, and I thank you for bringing it forward. According to the majority's memo, in preparation for the hearing, it will include 1, the role coercive interrogation practices play in eliciting false confessions, 2, pretrial detention, 3, pretrial evidentiary burdens federal and state practices placed on defendants, and 4, proposals for reform. Well, we've already seen how the majority has proposed to reform the pretrial stage. One member of this subcommittee, for instance, introduced the No Money Bail Act of 2019. That bill would completely eliminate bail in the federal system and make states that utilize bail for pretrial release ineligible for grants under the Byrne-JAG program. That's right, the sponsor intends to defund the police if states won't accede to his demands. And also, on New Year's Eve of last year, while no one was looking and without even a press release, the chairman of the Judiciary Committee introduced the Federal Bail Reform Act of 2020. His bill turns the federal pretrial release process on its head. With some very limited exceptions, his bill even creates a presumption for post-conviction relief while the convicted criminal is appealing the conviction. Chairman Nadler's bill prohibits the court from imposing any condition of release that may impose a financial on the person released. I suppose we should just all hope defendants show up for their court appearances even after convicted. Just as we're hoping tens of thousands of illegal immigrants will show up to their court hearings or report to ICE. It isn't working, which is why we have more than 1 million illegal border crossers with orders of removal wandering around the United States today. The Nadler bill also states that, quote, the judicial officer may not order the temporary detention of any person on the ground that they pose a generalized danger or a financial danger to any other individual or the community, close quote. So even if the judge or magistrate finds that the defendant poses a generalized danger to our community, the judge cannot temporarily detain the defendant who has already been convicted. I'm sure that will make everyone in the community sleep better at night. Last year, Chairman Nadler also proposed bribing states to empty their jails. In that proposal, states were to be given grant dollars to release prisoners who did not, quote, pose a risk of serious, imminent injury to a reasonably identifiable person, close quote. I guess it was okay to release that person if the injury might be hours or days away and perhaps not so serious. Again, there was no consideration allowed for a generalized risk to our communities when releasing these prisoners. You don't have to take my word when it comes to these so-called bail reforms. We will have a witness today tell her very compelling, very tragic story. And Madam Chair, I also offer into the record a letter from New Jersey State Assemblyman Mob Andrzejczak to California Speaker of the House, Anthony Rendon, warning him about the perils of bail reform. So, Madam Chair, I offer that letter into the record.
Without objection, so ordered.
Thank you. It is notable because Assemblyman Andrzejczak was once a proponent of bail reform, but when he actually saw it in action in his home state, he called it an absolute disaster. We will also look at pretrial discovery issues today. We need to ensure that discovery rules are equitable and that the government is held accountable. None of us want to see what happened to our late colleague, Ted Stevens. We don't want to see that happen again. That being said, we should not be looking to change discovery rules that risk endangering witnesses and crime victims, which is exactly what New York State did. Under New York's discovery rules, prosecutors will no longer be able to assure witnesses that their identity will be protected. And you don't have to take my word for it. Manhattan District Attorney Democrat Cy Vance said, quote, having to hand defendants a roster of who has spoken out against them just 15 days after their first appearance, absent a protective order, is a seismic change that undoubtedly will dissuade witnesses who live in all neighborhoods from reporting crime, close quote. I hope these are not the types of reforms my colleagues on the other side are considering. I understand that we will also be examining the practice of recording interrogations, and I certainly support such practices. In fact, I think not to do that is irresponsible and reckless. However, I point out that last Congress, Democrats twice rejected Republican amendments at markup to require custodial and non-custodial interviews be recorded by Department of Justice law enforcement agencies. I hope that is an issue that all of us can get together on in a spirit of bipartisanship. I thank the chair for holding this hearing today. I thank all of the witnesses for being here. I look forward to hearing from them and their testimony. And with that, Madam Chair, thank you, and I yield back.
The gentleman yields back. I thank the gentleman for his statement, and I thank the gentleman for his letter. Chairman Nadler seeks his regrets for not being able to participate this morning. So it's my privilege to turn to Mr. Jordan. I now recognize the distinguished ranking member of the full committee, the gentleman from Ohio, Mr. Jordan, for his opening statement. Mr. Jordan? We will yield to Mr. Jordan as appropriate. And so we will now proceed to welcome all of our distinguished witnesses and thank them for their participation. As I do that, let me also thank all of our members of Congress and this subcommittee who are here this morning as well. And I think it's an important statement to make that members are working, and we have worked all through the week on important meetings and hearings. And I'm very appreciative of the subcommittee members who are on this hearing this morning, this very important hearing. So again, we welcome all of our distinguished witnesses and we thank them for their participation. And now it is my privilege to begin by swearing in the witnesses. And if you would raise, as I turn to you, to turn on your audio. All witnesses turn on their audio and make sure I can see your face. Make sure that I can see your face. We're working to see everyone's face here. You need to turn it on so I can see their face. You need to turn it on so I can see their face. And the grid on. So I'm looking for every face here. So just a moment. And witnesses, have you unmuted? If everyone can say that they've unmuted. Has every witness unmuted?
Unmuted.
Raise your right hand in a visible way so that we can see you in the screen. Do you swear or affirm on the penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God?
I do.
I do.
All right. Thank you so very much. Let the record show that the witnesses answered in the affirmative. Thank you. We'll now proceed with witness introductions. Barry Scheck is a co-founder of the Innocence Project and a professor at Yeshiva University's Benjamin N. Cadover School of Law. There he serves as a director of clinical education for the Trial Advocacy Program and the Center for the Study of Law and Ethics. Mr. Scheck also was a staff attorney at the famous Legal Aid Society of New York, well known in its tenure and, of course, its history. Mr. Anthony Graves is a community liaison with the Harris County Public Defender's Office. In 1992, Mr. Graves was charged with and convicted of murder, despite a lack of a motive or any physical evidence connecting him to the crime scene. He served 12 years on death row before his conviction was overturned by a federal appeals court in 2006. He was released in 2010. His life since that has been a tribute to the values of this nation, and it reemphasizes the cruciality of this hearing and why we must insist on the assessment of the pretrial justice that occurs to those who may be wrongly accused. Premiel Daharia. Premiel Daharia is the co-director of the Institute to End Mass Incarceration at Harvard University. Prior to her current position, Ms. Daharia was founder and director of Defender Impact Initiative. Following law school, she worked at the Public Defender Services in the District of Columbia and as a federal public defender in the District of Maryland. April Fraser Kamara is the Director of Defender Legal Services Initiatives at the National Legal Aid and Defender Association. She previously worked as a public defender with the Public Defender Service for DC, as a re-entry coordinator, and more recently as a special assistant in the Juvenile Defender Unit at the Law Office of the Shelby County Public Defender. Michelle Hannessy. Michelle Hannessy has been a deputy district attorney for the County of Los Angeles for 22 years. She has tried over 100 jury trials, including 43 murders and 3 capital murders, which resulted in death sentences. She spent 5 years in the hardcore gang division, prosecuting gang murders, and has worked for the past 10 years in the major crimes division, handling high profile and complex cases. She also trains prosecutors and police officers across the state on gang homicide and death penalty law, and is author of the California Gang Crimes Manual. June Rogers is a resident of Millview, New Jersey, is a mother of 4 and a grandmother of 14. For the past 10 years, she has been a direct support professional for mentally and physically disabled. She is also the New Jersey chairwoman of the Victims' Rights Reform Council, a nonprofit organization. She has advocated against bail reform throughout the United States in honor of her son, Christian Rogers. We offer to her our deepest concern and also the recognition that this Congress, this House, passed the Victims of Crime Act that I was a lead sponsor on just last week. We thank her for her presence here today. Ruben Camper Khan. Ruben Khan is a partner at Keller Anderlo LLP, where he serves as counsel to a number of individuals and corporate clients. He has tried over 100 cases to jury verdict and has argued twice before the Supreme Court. Previously served as a public defender, first in the state of Florida and then in the federal courts. Prior to his current position, he was Chief Assistant Federal Public Defender for the Southern District of Florida, then the Executive Director of Federal Defenders of San Diego. Please note that each of your written statements will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. There is a timer in the WebEx view that should be visible on your screen. Let me as well indicate that you are doing a public service for your nation. Congress could not function without these hearings and witnesses with your personal lifetime experiences that help us contribute to the justice system of this nation. Again, we thank you for appearing before this important committee and this important larger committee, the House Judiciary Committee. Mr. Scheck, welcome, and you may begin.
Barry, you're on mute. Thanks.
Can I get the time back?
Yeah, you're ready. Good morning.
Okay, thank you. Thank you, Chairwoman Lee and Ranking Member Biggs, for the invitation to come and talk about pretrial reform to promote accurate and fair outcomes in our criminal legal system. My colleagues at the Innocence Project, as well as innocence organizations nationwide, examine cases where the innocent are convicted and the guilty escape apprehension. Each time that happens, it's a tragedy for the wrongly convicted, the persons harmed by the crime, and the families of all involved. Since 1989, the National Registry of Exonerations reports there have been 2,755 wrongful convictions, including 375 cases where exonerations resulted from post-conviction DNA testing. A recent study by the registry on official misconduct reveals extraordinary findings. Concealing exculpatory evidence occurred in 44% of exonerations. Black exonerees in general were more likely than white exonerees to have been victims of misconduct, but disparities were greater in murder cases, cases involving death sentences, and drug cases. Police officers committed misconduct in 35% of cases, prosecutors in 30%. However, in federal exonerations, prosecutors committed misconduct more than twice as often as police. False confessions were involved in 12% of exonerations. 20%, 1 in 5 cases, involved wrongful convictions where an innocent person pled guilty. The root cause of these wrongful convictions lies in some aspect of the pretrial process, which is why reform is so urgently needed. Congress should implement reforms in 5 areas, including 1, discovery reform. You recently legislated so that federal district courts are supposed to issue Brady orders that remind prosecutors of their obligation to disclose exculpatory evidence. But a more systemic reform would be open file discovery, where data is accessible online and disputes can be resolved as to what was disclosed and when, and the defense has an opportunity to actually look at the files. We know such an open file system can be implemented and successful because Texas has done it. It is the Michael Morton Act. Innocence Project client Michael Morton was wrongly convicted of killing his wife. The prosecutor in that case, who became a judge, hid exculpatory evidence. This case had national publicity, and it really shook the legal community in Texas. And I must tell you that prosecutors, defense lawyers, Democrats, and Republicans came together to pass the Michael Morton Act. This is an open file discovery system where everything is disclosed online. People can get to look at the files, and probably the most important provision in retrospect on this is pre-pleading discovery. At the time of a guilty plea, all parties say, here's everything that's been disclosed. The prosecutor acknowledges his or her obligation to have disclosed all exculpatory information, and then the plea happens. This would go a long way to eliminate that horrifying number of 1 in 5 people pleading guilty to crimes that they didn't commit. False confessions. False confessions are counterintuitive, as most people believe no one would confess to a crime if they were in fact guilty, unless they were in fact guilty. Yet 3 of 10 people proven innocent by post-conviction DNA testing actually confessed to crimes they did not commit. A false confession frequently creates tunnel vision for investigators, where they will ignore reliable evidence that could have led them to actually apprehend the person who was guilty. 3 things Congress can do that would really help. First, Congress codified the recordation of interrogations policy to ensure all federal investigations are recorded, interrogations are recorded from Miranda forward. Exactly what the chairwoman held forth here, and I was so glad to hear Ranking Member Biggs acknowledge that this was really important. You should add reliability as a factor in terms of courts reviewing the admission of confessions. That's number 2. And number 3, law enforcement should not engage in explicit lies and deceptions during interrogations. That leads to false confessions. Legislation banning deception during interrogations has been introduced now in New York, Oregon, and Illinois. Congress should look at those bills and follow suit. The trial penalty, which leads to innocents pleading guilty, along with the problems of cash bail. I urge Congress to pursue legislation in this area having to do as well with mandatory minimums. Improving access to forensic science by funding forensic science laboratories that are independent and allowing the defense access to real expertise. The Innocence Project client, George Rodriguez, was convicted based on unreliable serology from the Houston Police Department Crime Lab. Subsequent to that, the largest audit of a crime lab in the history of America was conducted. And at the end of that, what Harris County decided to do is they removed the forensic science laboratory from control by the police department, set up an independent governmental entity, the Houston Forensic Science Center. It has an independent board appointed by the mayor and a technical advisory board of scientists. It is the best crime lab, forensic science lab in the United States. People come from abroad to see it. It is transparent. It engages in blind proficiency testing. It is very efficient. It is the model that should be followed by Congress. You should be funding such entities. It is exactly what the National Academy of Sciences called for 12 years ago in its report on strengthening forensic science. Last thing, I know others will talk about it. I strongly believe that you must
Mr. Scheck. Thank you.
defense and focus on holistic representation. Thank you.
Thank you so very much. The gentleman's time has expired. We now recognize Mr. Graves for 5 minutes. Mr. Graves, if you would unmute and begin your testimony.
Thank you, Congresswoman. Thank you, Congressman Biggs. I'm excited to be here. August of 1992, 1 week shy of my 27th birthday, I woke up to a knock on my mother's apartment's door. It was the neighbor coming to tell me that the police was looking for me. Why? I decided to go outside and look for the police. An officer pulled up to in his patrol car. I stopped to wait on him to approach me. I didn't know that this encounter with the officer would change my life forever. I had no idea I was about to spend the next 18 and a half years behind bars, including 12 and a half on Texas death row, totally innocent. I cooperated with law enforcement 110%. So sure was I that the whole thing was some crazy mistake. They told me that another man had named me as his accomplice. That's it. He said my name. There was no other evidence to support his claim. I had full alibi. I was home with my then girlfriend that night long before the hours of the murder. There was no physical evidence to connect me to it. Fingerprints, footprints, blood on my clothes, or traces of embers. No skin cells or hair follicles from the victims. No eyewitnesses, except the man who said my name. And he had burns on his body when he showed up to the victim's funeral. I witnessed the nearly unchecked power of the district attorney's office and how one individual can have so much impact in our lives. I witnessed how law enforcement can get tunnel vision once they have a murder suspect in custody. I witnessed the role of the media in shaping opinions around cases before trial. I also witnessed how judges give wide leeway to prosecutors instead of heeding the actual facts or some notion of justice for all. All of these things eventually led to my wrongful conviction. Our criminal justice system is deeply biased and careless. Over the next 12 and a half years, I witnessed over 400 men being murdered at the hands of the state. I knew that I was innocent, and therefore I remained hopeful. I was convicted after a sham of a trial, replete with mistakes, bias, and tunnel vision. Whatever was said by law enforcement was gospel. Lack of facts to support their conclusions were tolerated. Exculpatory evidence was hidden from me and my lawyers. I was expendable. After my trial, I was sentenced to die and sent to death row. My execution date was set twice. I remember the first time I was told the state had set an execution date. I was escorted to the major's office in handcuffs. He sat me down and told me that the state had set an execution date. My conviction was overturned after a wonderful journalist worked hard to uncover all the errors in my case and the bias that accompanied it. I hope that this committee will find a way to address the issues that are plaguing our criminal justice system, okay? And fix it to make it better for us all, because every person matters. Every effort makes a difference. Believe me, I know. Thank you.
Mr. Graves, thank you so very much for that contributing testimony. Thank you is not an appropriate word for what you went through, but for you to be able to share that with us who are fact finders. Thank you for being here this morning. Ms. Daria, you're recognized for 5 minutes, and please let me know if I am pronouncing your name correctly.
Thank you so much. It's Premal Daria.
Thank you so very much. You're recognized for 5 minutes.
Thank you for holding this hearing and for the opportunity to testify. I've spent my entire career working within and around the criminal legal system, and I'm grateful for this opportunity to discuss important measures that Congress could undertake to address our country's addiction to incarceration and punishment and the crisis of mass incarceration that is devastating our communities. The United States leads the world in the rate at which it incarcerates its people. We have 4% of the global population, but 20% of the global prison population. With nearly 2 million people in prison on any given day, the United States incarcerates approximately the same total number of people as the two largest countries on earth, India and China combined. And in 2018, more than 10.7 million people entered US jails, the equivalent of locking up every person in Portugal, Greece, or Sweden. A large number of people in jail on any given day have not been convicted of any crime, but are instead awaiting trial and presumed innocent. And we cannot lose sight of the clear historical trajectory of racism and white supremacy that plays a part. Populations of those detained pretrial have more than doubled over 15 years, and they are disproportionately Black and Hispanic. This is not an accident, and it did not just happen on its own. We make choices every day, political choices, policy choices, cultural choices that shape our systems. When it comes to the criminal legal system, many of those choices have been made in the context of a history of racial oppression and also in the context of political narratives that stoke fear and ignore evidence. Regardless of where you fall on the political spectrum, it is hopefully safe to assume that there is a universal desire to keep our communities healthy and safe, and that differences arise when we think about how to get there. It is important to take a step back, given those differences, to make sure we're all using the same definition of public safety, a phrase that has in some ways taken on a life of its own. Popular conceptions of dangerousness, of violence, and of who commits crimes and why are very often not based in evidence or fact. Harm is, of course, very real, as is violence, and our communities need to find ways to both address harm and to address the people and the circumstances that cause it. But how we do that has to be grounded in what is real, in what the evidence says about what actually increases harm in our communities. We also have to recognize that our efforts to respond to harm or prevent harm can themselves cause harm, often to and within the very communities we are trying to protect. It is past time we started considering the very real human and community costs of removing people from their families, from their jobs, and from their homes when we think and talk of public safety. I am encouraged that the subcommittee is holding this hearing because the way we treat individuals before trial serves in many ways as the catalyst for so many other problems in the system. Approximately 98% of criminal convictions in federal courts are produced by a guilty plea, with high rates of guilty pleas in many states as well. Nearly every single person who is in a prison is there because they pled guilty, and they have generally done so without adequate access to effective counsel, without adequate discovery or information about their case, without adequate investigation or expert consultation, and with the specter of increased penalties and charges hanging over their heads. Our system is not the system of adversarial trials envisioned by its creators. It is instead a system of pleas, one grounded in coercion, imbalance, and opacity. Working to eliminate this coercion is essential to ending our system of mass incarceration, in which people are removed from their communities and incarcerated, subjected to onerous conditions and surveillance, and marked with punishments they will carry for the rest of their lives, in large part because we choose to allow prosecutors to possess a set of tools that they can use to extract guilty pleas. Prosecutors can pursue pretrial detention, they can upcharge cases, they can threaten offenses that carry mandatory minimum sentences, they can withhold discoverable material, they can obscure police misconduct. And because they can do all of this, not only do guilty pleas result, but the transparency mechanisms built into our criminal process, such as suppression hearings to examine police misconduct, evaporate. Throughout the testimonies today, you will hear evidence that the methods and policies we use are riddled with the potential for abuse and error. They must be constantly questioned and analyzed. We cannot sit back and assume we are doing things right. Indeed, we are quite clearly doing things wrong. There are a variety of reforms that Congress could pursue at every stage of the pretrial process that would not, on their own, fix the larger crisis, but that would make inroads toward the kind of thoughtful change we need. These include moving to cite and release and reducing the number of custodial arrests, guaranteeing access to counsel by moving the attachment and availability of counsel earlier in the process to the time of arrest and making defense attorneys available at police stations, limiting the length of interrogations, requiring recording, eliminating police officers' ability to lie and coerce, and ensuring the presence of counsel, ensuring speedy trial rights, implementing discovery reform, including the adoption of open file discovery, earlier provision of discovery and Brady material, eliminating the materiality requirement for Brady and Giglio in the context of pretrial disclosures, requiring disclosure prior to plea negotiations, and eliminating the Jenks Act, or at least requiring earlier disclosure of witness statements, including grand jury materials. We need jury pool and grand jury pool composition reform to include standards that ensure reflectiveness and enfranchising those with felony convictions to serve on juries. And finally, indigent defense funding standardization. Each area is described more fully in my written testimony. Thank you again for holding this hearing and for inviting me to present testimony.
Thank you so very much. The gentlewoman's time has expired. Thank you for your testimony. I now recognize Ms. Fraser Kamara for 5 minutes. You're recognized, Ms. Fraser Kamara.
First, I would like to say thank you to Chairwoman Jackson Lee Ranking Member Biggs, and the members of the subcommittee for inviting me to testify today. My name is April Frazier Kamara, and I'm Chief of Lifelong Learning at National Legal Aid and Defender Association, and also the co-founder and chair of the Black Public Defender Association. Today, I am going to focus my testimony on racial inequities. In the past year, we have witnessed an awakening, a resounding call for racial justice. But as some of you may know, the racial inequities and state-sanctioned violence against Black people did not begin with the killing of George Floyd and Breonna Taylor, but rather it is a part of a long legacy of white supremacy that started with slavery and that currently exists today within carceral systems, including the criminal legal system. Our country is demanding some systemic changes to the criminal legal system, and policymakers must meet the moment. Our failure to reckon with our past and specifically confront the legacy of slavery, Black codes, lynchings, Jim Crow, redlining, and the war on drugs has brought us to where we are today. So as Congress considers the pretrial reforms discussed today, it's crucial to call your attention to who is being policed, who is being criminalized, and who is being incarcerated. Black communities are disproportionately surveilled, arrested, and funneled into the criminal legal system. From arrest to incarceration, Black and Latinx communities are disproportionately impacted by the criminal legal system. They're more likely to be arrested, and once arrested, they're more likely to be convicted, and once convicted, more likely to receive harsher sentences than their white counterparts. Black women alone comprise 44% of the people incarcerated in jails today. Black men are 6 times more likely to be incarcerated than white men. And if we do not disrupt these systems of harm, 1 in every Black child born today can expect to go to prison in his lifetime. This is a crisis and it must end. There are 2 systems of justice in America. One for those who are wealthy, who are disproportionately white, and one for those who are low income, who are disproportionately communities of color. The legal theory of affording everyone equal constitutional rights under the law does not match the reality when you walk into courtrooms across America today. 80% of people accused of crimes in state courts are represented by public defenders. And most public defenders' offices are woefully underfunded and under-resourced. And there is no equal access to zealous representation in America. So as this committee considers the path forward for pretrial reform, I would urge you to center your responses on the lived experiences of directly impacted communities of color. When we discuss the word public safety, very rarely does that include the perspective of the Black community. Historically, public safety is defined for impacted Black communities instead of with them, which has led to the current reality where Black communities are being targeted rather than protected. We risk repeating the failures of the past if we do not stop and intentionally center the voice of the Black community. I will close my comments today with a call to action from Dr. King. History will have us to record that the greatest tragedy of this period of social transition was not the strident clamor of the bad people, but rather the appalling silence of the good people. As a nation, we have a choice. Will we remain silent on issues of racism and white supremacy, or face our painful history and present reality? I look forward to speaking with the committee today and engaging you on these important issues. Thank you.
I thank Ms. Fraser Kamara. Thank you very much for your testimony, and thank you for being here today. A powerful testimony. Ms. Hennessy, you're now recognized for 5 minutes.
Thank you. Good morning, Madam Chairperson and members of this committee, and thank you for inviting me to speak. I've spent nearly 23 years as a prosecutor in the largest local prosecutorial agency in the nation, and I'm proud to say it's an extremely diverse office that has a history of hiring and promoting women and persons of color. For the majority of that time in the office, my caseload has consisted of murders and sexual assaults. Any improvement to the criminal justice system that decreases the possibility of wrongful conviction while balancing the rights of victims and witnesses is laudable. As a prosecutor, I've seen the impact of the justice system, not just on the accused, but also on victims and witnesses. Intimidation of victims and witnesses is sadly not rare. More than one of my witnesses was murdered either before or after their testimony. I've had witnesses whose cars were firebombed, houses shot at, or were threatened in court as they testified with the classic index finger stroke across the neck gesture. These victims and witnesses didn't volunteer to become participants in the criminal justice system. They were drafted against their will by the acts of the accused. So we need a justice system that is fair to both the accused and to victims and witnesses. We've learned recently in California about changes in cash bail and what they can entail, and cash bail can disproportionately impact the poor, or more to the point, advantage the wealthy. But cash bail isn't necessary so long as the accused can still be detained based on a risk assessment that accounts for flight risk, victim safety, and public safety, and which allows judges to make appropriate deviations to address the particulars of individual cases. Detention considerations can't be based simply on algorithms, but need to include the nature and particulars of the crime, and certain crimes, due to the pathology involved, are more likely to be repeated at great harm to the victims. Domestic violence, child molestation, and child abuse are some examples. The abuse can not only be repeated, but can actually escalate once a perpetrator has been publicly accused. And on many unfortunate occasions, a victim of domestic violence was murdered when the accused was not detained pending trial. In California, changes to pretrial detention status are based on changes in circumstance or a triggering event like a willful violation of the terms of release. And I do want to note in California that people are provided counsel at their very first court appearance. Being found guilty of trial is a change in circumstance that justifies a change in detention status, because prior to trial, the accused is presumed innocent, but that presumption disappears upon a finding of guilt. So when a person is found guilty of a serious or violent crime that's going to result in incarceration, the presumption is that they will be put in custody absent a significant justification for a judge to deviate from that presumption. Videotaped interviews of arrestees and suspects are absolutely optimal. However, admissibility of a statement in court should never be conditioned on the use of audio or video recording, because too many things can go wrong through no fault of the officer involved. Exclusion of evidence should only ever be based on the constitutional considerations enumerated by our courts, particularly the Supreme Court of the United States. California's discovery laws require more and earlier disclosure than the federal system, and in the absence of a significant reason to withhold pretrial discovery, it's provided to the defense promptly. However, promptness is contextual and has to take into account the volume and nature of the evidence and the necessity of processing and documenting that evidence. And in the average murder case, for example, 15 days, as suggested by the New York proposed statute, is not nearly enough time. But in California, all witness statements are provided to the defense prior to trial, and as a matter of practice, many, many months, in fact, years before trial. There are, however, valid reasons at times to delay disclosure of evidence, such as risk of harm to victims and witnesses and risk of jeopardizing an ongoing investigation. But when delayed disclosure occurs, it's typically under the supervision of a judge who conducts ex parte review of the evidence and can issue appropriate orders. Police reports can often contain personal identifying information that can be used to target victims and witnesses. The privacy and safety concerns of victims and witnesses should be weighed against the rights of the accused. So in summary, I just want to say that while pondering the harm caused by incarceration, I implore you not to forget the harm caused by those who commit crime and the rights of the victims and witnesses to be free from threats, harassment, intimidation, and repeated interviews and hearings that take them away from their jobs and families. The safety and rights of victims and witnesses must be balanced against the rights of the accused. Thank you so much for allowing me to testify today.
Thank you so very much for your testimony and your service. Now we yield 5 minutes to Ms. Rogers, and we offer our deepest concern and sympathy for your loss. Ms. Rogers, you are on for 5 minutes to testify.
Good morning.
Good morning.
I want to say good morning to everyone and all of the witnesses and everyone. And I want to thank you for the opportunity to address you today as a victim of bail reform. I live in Millville, New Jersey, and bail reform was implemented in my state on January 1st of 2017. My nightmare began on April of 2017. Jules Black, a convicted felon, was taken into custody once again for gun possession, and because of bail reform, he was released back onto the street. While in custody, he was given a risk assessment test, which asked him questions such as, can you afford bail? Will you show up for all court appearances? And if you were released, do you promise not to commit another crime? Well, as a result, the algorithm deemed him to be of low risk and safe for release. The presiding judge in the matter was compelled to release him because the laws of bail reform required him to release him by the results of the test. 4 days later, Mr. Black gunned down my son, Christian Rogers, in broad daylight. Since then, Mr. Black has accumulated more charges in this case by using his girlfriend to threaten the eyewitness and the lives of her children. So now she also lives in fear of her life. These are the types of people who are benefiting from bail reform. Had it not been for bail reform, it is my belief that my son Christian would still be alive today. It is very disturbing that the policymakers are touting the success of cashless bail, but no one is considering the victims and their families in all of this. I cannot express enough the pain and the anguish that my entire family is suffering from losing such a kind and loving person as Christian was. He was well loved almost by everyone who knew him. It still pains me deeply whenever his two small sons often ask where he is and when is he coming home. I myself still have nightmares about seeing the picture of his lifeless body laying on the ground that someone had posted on Facebook. I was distraught when I found out that this all happened because of bail reform. I went to my local politicians about this issue, and one of them had the nerve to refer to Christian as being collateral damage. This angered me to no end. The very people who say they care about poor Black communities are only concerned about this paid political agenda. Politicians are telling us that cash bail is unfair to us poor Black people. But I'm here to say that not being able to live in peace is more unfair. We are not safe to walk down the street in the middle of the day. And as I continue my fight for the victims of bail reform, I would like to invite the policymakers to join me in having a further common sense dialogue about bail reform in our local communities, not just here in our nation's capital, and to please include the people who will be most affected by these laws. I want to thank you for inviting me to speak on this issue that means so much to me, and I look forward to answering your questions. Thank you.
Ms. Rogers, let me personally thank you for being willing to appear before a committee of the United States Congress, even in your pain. And I want you to know that your testimony has been received, and we thank you so very much for committing yourself to be here to provide the information that you've given us. Thank you again.
Thank you so much.
It is now my pleasure to recognize Mr. Khan for 5 minutes of his testimony. Mr. Khan, you're recognized.
Thank you, Chair Lee, Chair Jackson Lee, Ranking Member Biggs, and the other members of the subcommittee. Thank you for the opportunity to speak about these important issues today. And Ms. Rogers, I want to say my heart goes out to you. I cannot even imagine the pain of losing a child in those circumstances. I recently returned to private practice after 30 years as a public defender. And now I represent not only individuals, but also corporations, wealthy corporations. And I was immediately struck by the truism that a corporation fighting for its money has far more rights to information about the case against it than an accused citizen fighting for his freedom or his life. I want to try and put this in practical terms and consider what it means. Imagine this thought experiment. You members of Congress have a campaign manager who has violated campaign finance laws, but prosecutors suspect that you're involved. A grand jury subpoenas documents and witnesses. Your campaign manager is threatened with charges, but offered a sweetheart deal if she testifies against you. The government indicts you, offers probation if you plead guilty, but threatens 5 years imprisonment if you go to trial. So you're innocent. What can you do to take apart the case against you and prove your innocence? Well, you can't depose your accuser or anyone else for that matter. You can't subpoena third parties for emails or documents that might lead to evidence that proves you innocence. You cannot demand that prosecutors turn over all the evidence they have against you. And in many courts, even when prosecutors possess evidence of your actual innocence, they can withhold it unless and until you are actually in trial. So from law school on, we're told that a trial is a search for truth. But if that's really to be the case, we have to fix this system. And there are a few simple fixes. First, we need to recognize that Brady has failed. In Brady, the Supreme Court recognized that no criminal trial or sentencing can be fair if a defendant doesn't get information that could help the defense at trial or sentencing. But the court left it to prosecutors to turn over this evidence, and the results are predictable. Recent examples in New York, Judge Allison Nathan was forced to sanction prosecutors for burying exculpatory evidence. Those are her words. The Ninth Circuit upheld dismissal of the Cliven Bundy case, calling the prosecutor's repeated failures to disclose exculpatory evidence egregious. These are two examples, there are others. The last fall, prompted by the disastrous Ted Stevens prosecution, Congress passed the Bipartisan Due Process Protection Act to promote prosecutorial accountability. But the Department of Justice has resisted Congress's clear intent and continues to insist that a prosecutor alone should be able to decide what information gets turned over, arguing that its prosecutors are trained on what to disclose, to err on the side of disclosure, and to pursue justice, not conviction. Well, I believe that all this is true, but I know that it doesn't matter in the real world. And that's why we still see cases like Ted Stevens and Cliven Bundy. Prosecutors are simply not the right people to decide what evidence the defense sees. The trial is really going to be a search for the truth and not a sporting contest. Both sides must have equal access to evidence. This means that Criminal Rule 16, the primary procedural device for discovery, should allow discovery of any information likely to lead to admissible evidence. Criminal defendants should be given the same rights as civil defendants. Second, defendants need to be able to investigate their cases. When Congress passed the subpoena rule, Rule 17, it said the rule is substantially the same as its civil counterpart, which allows parties to seek documents leading to admissible evidence. But judge-made limitations have rendered the rule almost meaningless. Again, the revision needed is simple. Criminal Rule 17 should be amended so it mirrors Civil Rule 45 as Congress intended it to do. Third, trial by surprise has to end. The Jinx Act allows prosecutors to withhold witness statements until after a witness testifies at trial. Statements need to be provided well before trial. And fourth, allow defendants to depose witnesses. This isn't a radical proposal. The state where I began my practice, Florida, allowed witness depositions, and this was way back in the 1980s. Compelling pretrial testimony is a basic power enjoyed by every civil litigant and by prosecutors. It is absolutely wrong that accused citizens cannot do this. Making these simple changes will ensure that equal justice under law becomes a reality in this country. Thank you for the opportunity to address these issues, and I look forward to answering your questions.
Thank you so very much for your testimony as well, Mr. Khan. And let me, as I begin, indicate again how crucial the role of each of you witnesses are in the order of justice to provide us with the information that we are in fact needing to be able to address a myriad of issues, and particularly dealing with the question of justice, but also the question of freedom and the question of response to those victims or families of victims as well in this criminal justice system. Let me pause for a moment and determine whether or not Mr. Jordan has joined the hearing. Is Mr. Jordan joined? Mr. Biggs, has Mr. Jordan joined? If not, then
Madam Chair, I've reached out to him. He was on, and I think he had to leave, so I don't think he's come back on. I'm sorry about that. Thank you.
not at all. We wanted to extend him a courtesy. Thank you so very much. Please let him know that we wanted to make sure we extended to him a courtesy
Madam Chair, I will.
of his statement. Thank you so very much. We will now proceed under the 5-minute rule with questions, and I will begin by recognizing myself for 5 minutes, and we will then work accordingly with our members for this important hearing. Thank you so very much. Mr. Scheck, according to the September 2020 report from the National Registry of Exonerations of the nearly 3,000 documented cases since 1989 of people exonerated of crimes they did not commit, 44% involved government concealing of exculpatory evidence. What reforms would you propose to reduce the risk of wrongful convictions and ensure due process of people accused of federal crimes? Can you unmute?
Very simple. Open file discovery on the model of the Michael Morton Act in Texas. That is a really good statute. It also relies on pre-plea discovery. Everybody knows exactly what or what has not been disclosed, and the prosecutor's obligation, should be carefully defined, is to turn over all information that tends to negate guilt or mitigate the offense. Let me say I subscribe to every one of the recommendations that Mr. Khan put forward. They are critical if we can get them done. Depositions, like in Florida and lots of other states, that is crucial. The ability to issue subpoenas, no more trial by surprise. Everything that he put forward, I subscribe to and adopt.
Thank you very much. You also mentioned the whole idea of 1 in 5 pleading their case, pleading in false confessions. Do you have a solution to that?
Well, the things that lead to it, I think, number one, of course, if you don't have discovery, you wind up pleading. But the cash bail situation, there's no question. puts pressure on people when they see there's no way for them to go, particularly, frankly, in misdemeanor cases. The trial penalty is crucial. We've got to look at those mandatory minimums. I know that lots of our friends in the Cato Foundation, lots of different people recognize this problem. It is logical for so many people, when charged with these mandatory minimums, to plead guilty to crimes they didn't commit. And so I think that the bail situation, the mandatory minimums, trial penalty, those are all crucial reforms.
Thank you very much. Mr. Grave, your legal case was full of injustices up to the very end. Step after step, the prosecutor and investigators used unreliable information to put you on trial, and the prosecutor in your case withheld exculpatory evidence from your counsel. The injustices started at the pretrial stage of the process. Immediately following your arrest, what were the first unjust acts of justices that led to your imprisonment, and how should we prevent such injustices from happening to others in the future? Mr.
Thank you
Graves?
for that. Yes,
Thank
ma'am. Thank you for that question. Transparency. There's a lack of transparency at the initial stages. When I was arrested and didn't know why I was being arrested, I asked the person. They wouldn't tell me. They took me to the police station. I'm cooperating 110%. I'm asking officers, because I'm sitting there, can somebody tell me why I'm here? Nobody would talk to me. Then finally they came in, read me my rights. And if we'd had access to the intake video, everyone would have seen Anthony Graves knew absolutely nothing about this case. But that video never showed up until I was released. Also, they interrogated me for over 12 hours. At one point, the white officers asked if they just walk out the room and leave me with the black officer, right? And I'm like, I don't care. You don't have to leave, because I don't have nothing to hide. Well, the black officer asked me if he could record the conversation. I told him, sure. Yeah, I don't care. We never heard that tape that we recorded. Why? Because I was telling him that I was innocent. That never came about. Lack of transparency is leading to wrongful convictions at the pretrial stages. One thing I would say is that when someone is in the custody of law enforcement, I don't think law enforcement should be able to talk to him without his attorney, because that guy who is innocent, all he want to do is tell the truth. He don't care about you telling him what he say can and you will be used against him, because he's telling the truth, not understanding that they're going to pick apart everything he say and try to use it against him, because he is vulnerable at that stage. That was me. I just wanted to tell the truth. And they picked apart what I was telling them and tried to make it seem that I was lying. Lack of transparency is leading to wrongful convictions. That's what I would say.
Thank you so very much for that powerful testimony. My time has expired, and I will seek another time to continue my questioning. But at this time, I want to be able to yield to Ms. Bass. Is Ms. Bass? Ms. Bass, Ms.
Ms. Bass is here,
Wonderful.
but I would yield to you. You can take my time, and if I need some, I'll come back.
Well, thank you. Are you sure, Ms. Bass, in relation to the 5 minutes? I will take a portion of it up, but do you want to go ahead at this time?
No, you continue, and I'll take your last 2 minutes.
You're very kind. Let me just continue with Ms. Kamara. And Ms. Bass has yielded to me, members, so I'm not on extended time. I thank her for her courtesies. Prosecutorial discretion over what charges are filed and what charges are sought in the plea negotiations for each case means that prosecutors hold an immense amount of power in determining whose lives are defined by involvement in the criminal legal system and who can return to normal life. Can you just explain how an accused person's race affects charging decisions? Ms. Fraser Kamara?
Yes, Chairwoman Jackson Lee. In the federal system, African Americans are 2 times more likely to be charged with mandatory minimums compared to whites. In the state system, we see the use of habitual offender laws to result in a lot of racial disparities. As a former public defender, the reality is that we see every day in the courtrooms that the charging decisions are influenced by implicit and explicit bias.
Thank you. I am going to pause with a little bit of technical mishap here and ask Ms. Bass to pause on the time and ask staff to take note of the time remaining so that the clock can be cleared. We have 3 minutes remaining, but we're going to turn to Mr. Biggs at this time. Mr. Biggs,
Yes, Madam Chair.
you are
Yes.
not forgotten. You're recognized for 5 minutes. We paused in our time. Thank you.
Thank you. Appreciate that, Madam Chair.
You're recognized
And
for
I
5 minutes.
appreciate, thank you. And I appreciate the testimony of Mr. Graves, very powerful, as well as Ms. Rogers. Several states, including California, Maryland, New Jersey, and New York, have modified their.
Mr. Biggs, would you suspend? The clock needs to be
Yes, ma'am.
on 5 minutes for Mr. Biggs, please. Back to 5 minutes. All right. Mr. Biggs, continue. Your clock should start at 5 minutes.
Great, thank you. Several states, including California, Maryland, New Jersey, and New York, have modified their bail practices to eliminate or de-emphasize the use of monetary bail systems, and many of these reforms have resulted in increases in property and violent crime. As I mentioned in my opening statement, one New Jersey assemblyman referred to it as an absolute disaster and further stated that the public safety needs of citizens in New Jersey has suffered far greater than could have been imagined, close quote. Ms. Rogers, your testimony was compelling. Your story is truly moving. I'm very sorry to hear about the loss of your son Christian to a convicted felon who was released on bail, and I can't imagine your pain. And I appreciate you being willing to share your story today and your efforts in your community to make policy changes. And I understand you're the New Jersey chairwoman for the Victims' Rights Reform Council, which is a nonprofit organization. And in that role, you're a voice for crime victims and you wish to raise awareness. Could you please elaborate why you oppose bail reform as implemented in the state of New Jersey and elsewhere?
Okay. It's because I think that when releasing these people back onto the streets with no bail, no supervision whatsoever, they're not considering the victims, and we have here in New Jersey about 500 members in our organization. And a lot of their stories are pretty much the same. Um, the guy or the perpetrator is released with no supervision just because the computer system says that they're not a threat, and then they'll come right back out and commit more offenses. And a lot of them are deadly. So now you have people not wanting to speak up or or even report the crimes, because as soon as the person gets arrested, they're right back out. And we have to look at these people, because they're coming right back into our same neighborhoods, and we're absolutely terrified, and it's not right. Something should really be done about this. Now, when we had the old cash system, at least we could, call whoever's holding their bond and say, hey, this guy's riding around with firearms and shooting up our convenience stores or whatever, and someone will go and pick them up. And it would not cost us anything. I work very, very hard, and I know that my taxes are going to fund this cashless system with the ankle monitors and what have you. And it's a mess. It's a mess. And you all have to excuse me, because I get a little emotional every time I start talking about this, but
Sure.
it's a shame. And then it's like no one is listening to the victims. No one is taking this into consideration, that we are the ones that are living this nightmare, and it's just
Thank
unbearable.
you, Ms. Rogers, for sharing that. And explaining the situation regarding the release of the person who murdered your son. And I appreciate you again being here. Ms. Hennessy, some witnesses have offered suggestions for reforms. Of those reforms, are there some that you would support? And then are there some that would have negative ramifications in investigation and prosecuting of defendants? And I'm thinking of the open discovery that Mr. Scheck mentioned, as well as Mr. Khan's pretrial witness deposition mandates. So what do you think there, Ms. Hennessy?
Yeah, and there's some that I agree with and some that I don't. And I want to say up front, I don't believe that Brady has failed, and citing a handful of cases where it didn't work is like saying seatbelts don't work because some people wearing them died in car crashes anyway. That said, the federal rules of discovery require far less disclosure than California rules. We do not have a Jenks Act. There is no such rule in California, and I wouldn't condone implementing such a rule in California. All discovery is provided prior to trial, and we don't withhold discovery pending plea. However, I don't think that open discovery is workable. There's too much information that really involves a lot of personal information about victims and witnesses that has to be closely guarded, and internal systems like CLETS, rap sheets, that has basically everything an individual would need to commit widespread identity theft or use the information to identify, threaten, harass, and injure victims and witnesses. I also really do not believe at all that victims should be compelled to submit to depositions as in civil. Even in civil cases, depositions are used to harass and intimidate witnesses. And compelling them to submit to repeated interviews against their will is a violation of their rights and disturbs their peace of mind, especially for child witnesses and witnesses of crimes like sexual assault and abuse. Repeated interviews for these victims just increases the psychological damage that they're subject to. And this is where the rights and the needs of the victims and witnesses really need to be balanced against the accused.
Thank you. Now yield back, Madam Chair.
Thank you so very much, Mr. Biggs. And now I'm going to yield to Ms. Bass. Are you ready, Ms. Bass? You have 3 minutes
Yes.
remaining on the clock.
Yes, thank you. And I will just ask one quick question. I wanted to understand the impact of this system on juveniles, young people that are involved in the juvenile justice system.
And who?
Any of the witnesses, please.
Representative Bass, I'm happy to answer. When we look at the juvenile justice system, we see disproportionate minority representation in pretrial phases. Specifically, you see 62% of children who are held pretrial in juvenile adjudications are children of color. So similar to the adult system, despite a lot of reforms that have taken place within the juvenile system, we still see glaring disparities around what children are held in detention facilities.
Yes, and given the disparities, I would certainly like to know what kind of reforms some of the other witnesses feel should take place. I know California is quoted a lot. Of course, I would disagree that everything is in disarray in California. The reforms are not working. Even before the reforms passed, there was moves to repeal them. So in some reforms weren't even given an opportunity to be implemented. And I do think in California, what we should have done is we could have built out the prevention side before we actually did some of the reforms. But anyway, maybe one of the other witnesses could explain, especially the woman representing the DAs, could explain what type of reforms are needed given the extreme disparity.
Well, one type of reform I'd like to see specifically for the juvenile system is just more funding for the juvenile justice system, more funding for those facilities where juveniles are unfortunately incarcerated. And we're talking about juveniles sometimes. We're talking about people who are, 17 and a half years old and 6'1". We had an unfortunate incident recently where a I believe it was a social worker in one of our juvenile facilities, was beaten to death by a number of the individuals being held there. And some of them were juveniles, and they have now killed this man who was a social worker at that facility.
Excuse me, let me reclaim my time. Yes, I'm actually aware of the case that happened in Los Angeles, but the vast many juveniles that are in the system, you can quote an extreme case. In California, we've moved to shut down juvenile prisons, period, and to transfer it over to Health and Human Services, given the science that we know now about brain development and the responsibility of juveniles. Clearly different things need to be done instead of what the current system is.
Well, as I said, I encourage further and more extensive funding of the juvenile system. If you've ever been to the East Lake Juvenile Facility, you'll see it's terrible. It's terrible. So put more money into resources into preventing these individuals from entering the system, and more resources into rehabilitating them once they're in.
I'll yield back my time in a minute, but that doesn't speak to the type of reforms that need to be done. I agree there needs to be more, more funding, but I yield back to you, Madam Chair. Madam Chair?
Yes, thank you so very much for yielding back very much. You've asked a very important question. I don't know if I can get one in the next 1 minute, but I'll quickly try to do so with Mr. Camper Khan before I yield over. Mr. Camper Khan, what are the most pressing problems involving law enforcement's use of informants in federal cases? How can we best address them? And I basically have 53 seconds. We'll come back to you, but are you able to respond? Mr. Khan?
Yes, I'm sorry. I needed to remember to unmute. Thank you for your question. So I think that we should begin by noting that no one should be particularly surprised that informant testimony is at the heart of some of the most egregious failures in our system. If I responded to your question by proposing that the way to address the problem is really to level the playing field and allow defendants to pay for testimony and for the results of testimony, you would all think it absurd, because you would all understand that this is not the way to produce a reliable system that we can trust. But if we're going to use informants in the system, if they're going to continue to be a part of the system, we're going to pay people for their testimony, either in freedom or in other goods, then there are two practical solutions that I could suggest to reduce the risk of wrongful conviction and to increase fairness. And the first of these is to mandate recording of all interaction between informants and law enforcement from minute one, and to turn that over to the defense. And the reason is this way juries can understand exactly what implicit promises and assurances are given to informants, not merely the explicit promises. But the other thing is that juries then can see these small and subtle ways that informants shape their testimony to fit prosecutors' narratives. In the cases in which...
Mr. Khan, my time has expired, and
Sorry.
we'll let you finish that at another opportunity if we're able to take a second round. Thank you so very much. Thank you so very much. Let me yield now to Ms. Sparks for 5 minutes.
Thank you, Madam Chair. I appreciate this important conversation. I have to tell you, I agree that alternatives as ineffective pretrial services could be very beneficial for some of them.
Are we able to hear Ms. Sparks? Ms. Sparks?
I think she's frozen, Madam Chair. Nobody can hear her.
Then it seems,
I'm sorry,
Mr. Biggs?
yeah, I think Madam Chair, I'm trying to reach out to her, but she looks to be frozen, and so If you could go to our next questioner on our side, that'd be great. Thank you.
All right, I will do so. Do you have the list of the next individual, Mr. Biggs? Is she back?
I have the list. The next one would be Representative Shabbat from Ohio.
And the clock will go back to 5. Mr. Shabbat, you're recognized for 5 minutes. Mr. Biggs, you work with Ms. Sparks.
I will, Madam Chair.
Mr. Shabbat, you're recognized for 5 minutes. And thank you, members, for bearing with us. Mr. Shabbat? Can you unmute Mr. Shabbat? Is he present?
I'm not sure he's still with us, Madam Chair.
All right, Mr. Biggs, you have another person.
Yes, Madam Chair. I have next Mr. Tiffany.
Mr. Tiffany. Mr. Tiffany, you're recognized for 5 minutes. Unmute.
You still there?
So on you, Mr. Biggs. Chair.
Madam Chair, hey, let's try Mr. Massey. I'm pretty certain he was there just a second ago, so let's try that.
Mr. Massey? We're prepared to recognize you for 5 minutes. And I don't see Ms. Sparks back. Mr. Biggs, you're on again.
Then I would go to Mr. Owens, Madam Chair. Mr. Owens, whom I see.
Mr. Owens? Can you unmute?
Yes. Thank you so much. And I just want to take a couple minutes. Can you hear me okay? Am I coming through?
You're recognized for 5
Am I
minutes.
coming through okay?
Yes, you're recognized for
Okay.
5 minutes.
Okay. Mr. Biggs, if anybody wants to take over my last, I just want to have a couple comments I just wanted to share. Earlier, we were talking about the juvenile system, and I think it's very important that we recognize that this has nothing to do with the color of a person's skin. It's policies that surround these young people that put them in a position where they have really no hope. And I'm speaking from an environment in which I grew up in at a time where we had 70% of Black men committed to their marriage, to children in their marriage. We now have flipped that over upside down based on policies. We now have in the state of California, 2017 DOE study, 75% of Black boys in the state of California in 2017 could not pass standard reading and writing tests. So what we have, you wonder why there's such a disproportionate number of Black young boys and men. It's because we're not giving them an opportunity to work, to be educated, and to tie this into just the color of their skin is not correct. We need to make sure we're tying it into the policies that is going to put these Black families in the place that they are in right now, and also making sure that those families that are still trying to find safety in their communities are safe. And at the end of the day, we have bad people being released into a community of good people. Bad people will end up causing havoc and terrorists and fear, and we just cannot allow that to happen. So let's make sure as we go through this process of reform that we look at the beginning, the genesis of this, and it goes back to the family unit that has been turned upside down over the last 50, 60 years by policies, I think, purposely put in place to make sure that that our young people do not have hope in our country, do not believe in themselves, and they're angry, and they'll go out therefore and do the things that they don't believe that is not going to give them the opportunity to have the experience of the American dream. Just want to make that real quick point. Because of my experience, again, starting a program here in Utah, Second Chance for Youth, I'm the founder. And so I've been working with the juvenile system for the last 3 or 4 years. It's been a dream of mine for decades. My dad and I talked about how can we get our young people believing in our country again. And it comes down to policies, my friends. So let's make sure we change those policies to give our kids hope that they can succeed and move forward. I yield back.
The gentleman has yielded back. I now recognize Ms. Demings for 5 minutes.
Good afternoon, everybody. I want to thank the chair and the ranking member for this hearing. From Miranda to Gideon, I am quite familiar with both. I truly believe that the level of representation a person is able to receive or how long a person sits in jail waiting to go before a judge should not be determined by a person's ability to pay. Everyone knows I spent 27 years in law enforcement, and during that time, I served in every rank, including the rank of chief of police. I served as a detective and as a detective sergeant. I took my oath to the Constitution, and I say that in perfect peace. I took my oath to the Constitution very seriously, and I do believe that in any state, anyone who was treated unfairly, inhumanely, or trapped into making a false statement deserves justice. I'm glad we are advocating on their behalf. Mr. Gray, I cannot imagine serving 18 years on death row as an innocent person. Hear me clearly. That is shameful. Miss Rogers, my heart goes out to you and your family for your loss. But today, Madam Chair, I chose to advocate on behalf of victims of crimes. As we well know, victims come in all ages, genders, cultures, and races. But too many of the victims, during my experience as law enforcement, let me make this clear, looked just like me. It appears we seldom remember the victims, their faces, their stories, their voices, and their rights these days. The victims in Georgia and Colorado had a right to live, and so many other sons and daughters who have been gunned down in a country that we say is the greatest country in the world. Let's remember the victims who have been raped, robbed, assaulted, victims of economic crimes, and had their life savings stolen from them. People who have been victims of hate crime, that's a familiar one these days because of who they are or who they love. Today, Madam Chair, I choose to use my very limited time advocating for the victims of crime, and I will continue to use my time, my talent, and my energy to advocate for justice, which does include justice for the victims. And with that, Madam Chair, I yield back.
I thank the gentlelady for her eloquence, and she is well positioned on this committee to find the kind of balance and respect for those unjustly accused and convicted, and as well as she so eloquently said, those who are victims. Because isn't it interesting? Those individuals seem to fall heavily in communities of color and particularly African Americans. So thank you very much for your testimony dash statement today as a member. Thank you so very much. Appreciate it. It's now my desire, Mr. Biggs, to call upon a member. Is Ms. Sparks ready?
Thank you, Madam
Madam,
Chair.
there
Can you
she
hear me
goes.
Yeah.
okay?
Thanks.
Yes, for Ms. Sparks, you're recognized for 5 minutes.
Okay,
Thank you.
thank you very much. I appreciate this hearing today. I think, effective pretrial services for lower risk crimes could be actually, for low risk offenders, could be very beneficial. And we have actually, I talked to Stephanie Ruggles, she's director of pretrial services in Hamilton County, Indiana, in my district, and they really have a gold standard system with involvement of stakeholders, with follow-up, and then other wraparound services, job placement, housing placement, and with safety rates 87% when people don't come back into the criminal justice system. But we also, it's important to have effective mechanism. And when I discuss with her what is really some of the things that make the system successful, additional to all of the involvement variety of stakeholders, she mentioned also very effective pretrial risk assessment tool, which were validated with researchers. So my question is for Ms. Hennessy, what other things you've seen in the system that have been working effectively to make sure that we have right mechanism tools to rehabilitate people, that have a right framework and things that may be effective, make sure that we get people second chances, but also have a proper system that addresses really harsh crimes. So what things could you suggest?
Well, I would suggest putting far more resources and far more study into rehabilitation before releasing individuals early, particularly violent and serious offenders, to make sure they're rehabilitated before you start releasing them early. Unfortunately, the California Department of Corrections and Rehabilitation and the Los Angeles County Probation Department have a woefully poor rate of rehabilitating individuals. And I just don't think they put the same resources into that. And it's a government agency, you know, they have limited resources, as do all government agencies, including my office. But there are groups in Los Angeles who've been very successful at rehabilitation, including rehabilitation of violent offenders. And one in particular is the Anti-Recidivism Coalition in Los Angeles. But it is a resource-intensive program. That said, they have very low recidivism rates for their offenders. They have what they call credible messengers who enter the prisons and start working with individuals in prison while they're still incarcerated. And they have had very successful rates, but as I said, it's labor intensive and resource intensive process, and they really don't. They're also really strict with their people they're supervising, and they will violate someone or refer them to the court for violation for really very minor infractions, and they're strict. And I think that the level of accountability combined with the credible messenger aspect is what's made them really successful.
Okay, well, thank you. Thank you. I yield back, Madam Chair.
Thank you so very much, Ms. Sparks, for your participation. And I'm now delighted to yield 5 minutes to the gentlelady from Georgia, Ms. McBath.
Thank you so much, Madam Chair. And first and foremost, I just want to say thank you for everyone that is here today. Thank you for your expertise, and thank you for sharing your stories with us as to how we're going to be able to really promote public safety while also making sure that our courts are seeking true justice. And I especially want to thank those of you that are here today to share your personal stories. Mr. Rogers, I am so sorry for your incarceration, your unjust incarceration, and I'm so happy that you're free here today to be able to testify before us. And of course, Ms. Rogers, I am so sorry for your loss, and I can honestly say that with full empathy to my core, because I know the pain of losing a son to senseless gun violence, and there are just absolutely no words that can bring back your son, Christian, just as there are none that can bring back my son, Jordan. And I know that as mothers, all we can do is just completely speak our truth and share our story. So I thank you for being here today to tell us about your son. And I think it's critical that we always continue to hear from victims and survivors of gun violence and listen to their needs. Last week, we were able to pass a bipartisan bill to support services for victims of crimes and their families. And I know how important that funding is so that so many of our communities and families can try to heal again. And we can never bring back a loved one, but I hope that our bipartisan bill to fix the Victims of Crime Act funding will give meaningful support to those who really need it. Mr. Graves, I'll start with you. Your testimony speaks to the potentially enormous human toll that can come from wrongful detentions. We know that pretrial detention can absolutely be deadly. And unfortunately, according to the Bureau of Justice Statistics, suicide continues to be the leading cause of death in jails, where many people are held for pretrial detention. Mr. Graves, during your pretrial detention, do you ever recall if you had any access to mental health services?
Thank you so much for asking me that question. No, I don't recall. I never had access to any mental health.
And I'm sorry to hear that. Because, yeah, I'm sorry.
I was in jail. Yeah, I was in jail 2.5 years before trial. And I just want to, bail reform is hard. I just want to address something I heard earlier. Bail reform is hard, and I know, and my heart goes out to Ms. Rogers and you for losing your child. But I sat in jail 2.5 years with no bond, and I was absolutely innocent. Wasn't even in the same town that the crime happened in. Had alibi witnesses who knew I was home. I was with my family. And I sit in jail 2.5 years with no bond. So I understand that. But are we going to be a nation of laws or what? Because we are supposed to be presumed innocent until guilty. So are we going to be a nation of laws? If we are, then we have to actually let people out that hasn't been convicted? Or are we gonna kind of massage that law? And we're gonna decide based on our emotions whether this person should stay in jail or not because he done something to me. Our system cannot be based around someone's personal experience, but it has to be what's best for us as a society. And I'm saying if I'm innocent till proven guilty, why am I still in jail 2.5 years for something I didn't do? So
Well,
it's
thank you
very hard.
Well, thank you so much for that, Mr. Graves. And once again, we are so sorry for the injustices that have been, that you've suffered by. And I'd like to move on. Ms. Daria, your testimony noted that among those listed in the National Registry of Exonerations, 70% of those with a mental illness or intellectual disability made a false confession. What can we do to enable public defenders and mental health professionals to identify those with mental illness and prevent false confessions?
Thank you. And thank you for the question. I want to sort of echo condolences to those who have shared their personal experiences as well, and offer some thoughts about how we can identify precisely the kinds of things that you've mentioned. The vulnerabilities of people that are impacted by the system, right, are broad. They span youth in terms of age of people who are impacted, mental health issues, intellectual disability, sophistication in terms of understanding the legal system and how it works. There are a number of pieces there in which people can be further, victimized and harmed by the process, and in which we need to take safeguards to ensure they're not. With respect to false confessions in particular, there are scores of reports and studies and pieces of evidence that support a number of reforms that can minimize the number of false confessions. I've named some of them earlier, as have Mr. Scheck and others. But first and foremost, access to counsel and meaningful access to counsel. Counsel should be made available at the time of arrest and made available at police stations. Currently, our system allows for the invocation of the right to counsel, but that doesn't actually mean that counsel should
Daria, if you could wrap up your answer, if you could summarize the answer, thank you.
Sure. So access to counsel, eliminating the ability of police and law enforcement to lie, which is currently fairly unfettered, and ensuring that there are time limits on detentions as well. So those are all measures that can be taken immediately to address the likelihood and prevalence of false confessions.
Thank you so much for your answers. I yield back.
Thank the gentlelady for her important questions as well. Thank you. Let me now yield 5 minutes to Mr. Fitzgerald. Mr. Fitzgerald, you're recognized for 5 minutes. Can you unmute, please?
There we go. Sorry about that, Madam Chair.
That's fine.
We don't have private bail bonds in Wisconsin. We don't have it. We haven't had it since 1979. And I think there's 3 other states. If I'm correct, I think Oregon is one of them. I think Kentucky. Mr. Massey might want to talk about how they do it in Kentucky. I don't think they're all the same, but I know this is a very broad hearing we're looking at, but there are very specific things I think that the states are doing that could be applied, and I think it's worth examining. The one thing I just wanted to go back to, and I think that Ms. Hannessy had touched on this, but it might be lost, and that is that under the federal rules on criminal procedure, the Supreme Court precedent ensured that defendants obviously get a fair trial under due process with the 5th and 14th Amendment. But I think what's lost sometimes is, can you walk us through kind of why pretrial detention is really more based on the risk of harm to the public and to the victim, and then flight risk as well? I mean, this isn't about the individual's prior record or convictions. It's about, a snapshot right there in front of the bench on whether or not the person is a flight risk. And I'm wondering if you could just address that.
Yeah, prior to some recent changes, bail was based upon the crime charge, and it was presumed to be an accurate charge. And it is, in a sense, based on the person's history, not so much criminal history, but if they've had prior failures to appear, which are recorded on rap sheets. If they've had a failure to appear in court, a willful failure, that information will be in their probation reports or their rap sheets. And that is a legitimate consideration for the court. If they've previously been ordered to appear by a court and willfully failed to do so, that's a significant consideration. But also the crime charged and the nature of the crime charged. Clearly, it is a risk to the public and a risk to the victims to allow individuals who have committed violent offenses to be released into the public, particularly in those crimes that target known individuals. And I'm talking about domestic violence, child abuse, child molestation, rapes, and those types of offenses where the perpetrator is fixated on an individual. I'll also mention stalking. We have a lot of celebrities here in California, and we have some people who, unfortunately, and probably due to some mental health issues, do stalk celebrities here. And it can be quite frightening and dangerous. The fact that someone suffers from a mental health issue doesn't mean that they cannot also perpetrate a violent crime. So those are the kind of offenses and the types of circumstances that the judges should be able to evaluate and look at in determining whether or not a person is appropriate for pretrial release. In comparison, for misdemeanor offenses and nonviolent offenses, the detention levels are very low and minimal because they are not an immediate risk to the public and to public safety.
Oh, very good. Thank you, Madam Chair. I just want to touch on that point and appreciate the time in the hearing this morning. I yield back.
We thank the gentleman for his time, and we thank the gentleman for yielding back. My pleasure now to yield 5 minutes to the gentlewoman from Pennsylvania, Ms. Scanlon. Scanlon, you're recognized for 5 minutes.
Thank you. Thank you very much, Madam Chair, and thank you all for being here. As we're talking about these important issues, of course, we each bring our individual experiences to the conversation, and I'm particularly concerned about how pretrial practices impact juveniles in our criminal justice system, and particularly how insufficient access to counsel and manipulative investigatory techniques can lead juvenile defendants to confess to and accept plea bargains for crimes they didn't commit. Before I came to Congress, I often worked at the intersection of child advocacy and the school to prison pipeline, including participating in the defense of some children who were caught up in what became known as the Kids for Cash scandal in Pennsylvania. For those who don't know about it, between 2003 and 2008, hundreds of Pennsylvania teens were sentenced to for-profit detention centers in which the sentencing judges had a financial interest, often after they'd been pressured to waive their right to counsel or confess to crimes that they didn't commit. Since coming to Congress, just in the last 2 years, I've seen 2 juvenile detention centers in my district close after widespread abuse of the children who'd been housed there. And in some of the most heartbreaking cases, it appears that juveniles who were sent to the detention centers for having allegedly committed misdemeanors were then beaten by guards, and when they tried to fight back, they ended up charged with aggravated assault, felonies, and sent to adult prison. So, the Supreme Court has long held that juveniles lack the maturity and mental acuity to be treated as adults in our justice system, underdeveloped sense of responsibility. They can be impetuous. Basically, their prefrontal cortex is not completely developed. So that's the angle I'm interested in with your testimony. Ms. Daria, you testified about the human cost of removing people from their homes and families. Can you speak to the impact of the human cost on juveniles of removing them with pretrial detention?
Absolutely. Thank you for the question. The human cost of removing anyone from their communities is tremendous, and we shouldn't underestimate it in any of these conversations. Juveniles, of course, have their lives ahead of them, and the earlier that we start exposing them to the trauma and harm of the pretrial detention system or the carceral system at all, the more we're setting people up to continue the cycle of harm. It is a cycle, right? We respond to harm and trauma with additional harm and trauma, and none of it adds up to healing or to safety or to health. And so acknowledging that early, when children should be in school, when children should be supported by their communities and, at home with their families, and learning to socially develop, and rather than providing all of those things and investing in that, we are exposing them to violence, to harm, to coercion, and to trauma. And I think an important piece of this, as it relates to, as you mentioned in particular, confessions and coercion by law enforcement, is that, and this is true for adults as well, that people at this stage of proceedings are presumed innocent, and that the law enforcement approach currently presumes guilt. Right? A lot of these coercive tactics, a lot of these attempts to extract confessions and to lie in order to get certain responses presume guilt. And that's not what our law demands. And it's not what law enforcement should be engaging in. And so I think that's an important precursor to addressing the further harm of pretrial detention.
Thank you. And I would love to speak to all of you all day. Mr. Scheck, your testimony touches on several issues that have impacted the juvenile defendants who I'm thinking about in these questions. Could you address how juvenile defendants may be impacted by, we've talked a little bit about deceptive interrogation, pressure to avoid the trial penalty, and how holistic defense mechanisms might help them, such as through special education, mental health supports, et cetera?
Yes, I'd be glad to. I mean, one need not say anything more than the exonerated 5 in New York, or Khalif Browder, somebody that was held in on cash bail, and suffered terribly, and was there forever in terms of solitary confinement. But the American Psychological Association has issued clear papers about the increased risk of false confessions among juveniles, and that's why eliminating deception, in particular, by law enforcement in terms of interrogations is extremely important, certainly when juveniles are concerned. And of course, the recordation, and most importantly, in some ways, people overlook this, that there should be a requirement, a factor, courts to consider that the confession received, particularly from a juvenile, is reliable. In other words, there's corroborating evidence that shows that the juvenile's confession, or anyone is confessing to a crime, that with information that only the real perpetrator and the police would know, or they said something that led to other incriminating information. Without that reliability requirement, which unfortunately in Colorado versus Connolly, the Supreme Court has not given us, courts cannot intelligently assess confessions to see whether or not they're reliable and not false.
Thank you, and I yield back.
Thank you very much for your testimony. The gentlelady yields back. Now I'd like to recognize Mr. Massey for 5 minutes.
Thank you, Madam Chairwoman, for having this important bipartisan committee hearing. Ms. Daria, you touched on speedy trials, and I'd like to relate a story from when I was county executive. Our biggest line item in the budget next to the roads was the jails. And I noticed a pattern over there. We had overcrowding, and they were always trying to get us to build more jails. And that wasn't the problem. The problem is we had too many people awaiting trial. But there was this perverse incentive for the judges at the state level to keep inmates in there because they would pull them out after 16 months and then encourage them to plead guilty for time served. Now, the interesting thing is the counties paid for the time served. It went to the county budget, and the state didn't have to pay for the incarceration. So in Kentucky, at least, we've got the state pushing the burden of incarceration, the fiscal burden, onto the counties. So they have this incentive to get the inmates to serve time in county jails before they come up. This wouldn't be a problem, and unreasonable bail wouldn't be a problem if we actually just followed the Sixth Amendment, I feel like. What is right now the accepted threshold for a speedy trial and has, in the Supreme Court or elsewhere?
Well, as you've described, even just in describing the county and state differential there, the rules differ by state. Our criminal justice system is a completely, piecemeal jigsaw puzzle of rules and statutes, and the approaches to them have been different everywhere, particularly in the pandemic, when a lot of jurisdictions attempted to address their speedy trial statutes and to expand the time that people could be held to try to manage the pandemic. DOJ did that for the federal government as well, where U.S. attorneys were seeking to enlarge the time that people could be held. So there's no clean answer to the question of how long people are traditionally held or generally held in different places. I do think that your question touches on a bunch of these different issues that people have been discussing today because they all relate to each other, right? The question of pretrial detention being part of how pleas are coerced. And the question of whether discovery is provided earlier in the process so that people can make decisions and move on. These are all interconnected and they relate to the amount of time that people spend pretrial and to when and how they can make informed and voluntary decisions. So I think they're all interrelated.
Since you mentioned discovery, that's a good transition into my next question, which deals with facial recognition. And you sort of have the same problem, I think, when you use canines to establish probable cause. How do you cross-examine a canine? And I think you shouldn't be able to use a dog to establish probable cause because really it's up to the handler to say that the dog saw something or smelled crack instead of a cheeseburger. And but now I'm worried that we're going to have the same problem with facial recognition. How do you cross-examine an algorithm? And will the Brady material be available? You know, did the algorithm identify 10 other suspects that aren't being prosecuted? And is that made available? So if any of the witnesses would like to speak to that, I'd like to open that up for a brief comment.
Yeah, I can address that. You're absolutely right in terms of facial recognitions because there is no clear discovery of close matches. And the way it comes in courts right now is that it's viewed as a quote unquote investigative lead, right? So we don't even have to, it's an investigative method. So we don't even have to disclose it to you. And if I could go back just 1 minute because Mr.
I'll give you 30 seconds.
Yeah, but you made a great point about pretrial detention and exactly the situation you described. And I don't want to leave with that, calling attention to holistic representation. There's this amazing study out of the Bronx where they compare holistic representation to traditional defense. And it found that over a 10-year study, that in terms of pretrial custodial sentences and custodial sentences overall, a 15% decrease of 1.1 million fewer days of custodial punishment. It was a huge savings. It's a much better way to do defense, and it really will promote safe communities.
Thank you. In my remaining 30 seconds, I want to point out that the racial and economic injustice extends beyond those who are incarcerated. Ms. Camara mentioned that African American males are 6 times more likely to be incarcerated than Caucasian males. Well, when you go do an instant background check to purchase a firearm, it turns out that within races and ethnicities, a lot of people share the similar surnames. And I've been trying to get from the DOJ and the ATF, because they collect this data, the false positives that occur at a higher rate among minorities when they go to try and purchase a firearm. There were 112,000 denials in the last year we have data and only 12 prosecutions. Most of the denials are false. And I am very concerned that a lot of those denials are racially biased because of the mass incarceration of African American males and the fact that a lot of Latinos share surnames among them. So maybe we could get that data from the DOJ at some point. Thank you.
Mr. Massey, your time has expired, and even though your particular example will be challenging to some of us who certainly want the legal purchase of gun, but we certainly don't want the illegal purchase, but you are making a very good point. I hope that we'll have a bipartisan opportunity to work on some of the issues that you raised as it relates to pretrial detention and pretrial procedures. Thank you so very much for your questioning. My pleasure now to recognize Mr. Cicilline for 5 minutes. Thank you for your presence. And let me also acknowledge Ms. Dean as well, being present at the hearing today. Mr. Cicilline, 5 minutes, and you're recognized. Thank you.
Thank you, Madam Chair, and thank you to our witnesses. It's great to see all of you, and thanks for your testimony. And of course, I too want to extend my condolences to Ms. Rogers for her terrible, terrible loss, and to Mr. Graves for what you experienced. And thank you both for your willingness to share your stories. Mr. Scheck, thank you for the great work that you do. It's good to see you again. It seems like the reliance on these false confessions that are produced as a result of deception by law enforcement is a pretty easy thing to fix by simply prohibiting that practice. You agree? Mr. Scheck? I think you're on mute. I think you're muted.
Sorry. I absolutely agree. And I think what's fascinating now is if you look at experts in interrogations who deal with high-value detainees, one of the major companies, Zawadzki, I can't pronounce their name, the professional interrogators, they don't believe in deception. They know this can produce false confessions. And it is a simple thing, and the legislation is good. They don't do it in Europe.
Right. I don't think it's done in any other Western countries.
Right.
And I think you're right. I think that's an easy thing for us to fix, and I hope we will do that. And I also think the recommendations that Mr. Khan made, that you also supported, are very sensible. It reminds me, when I was a public defender and then a criminal defense lawyer for most of my career, and I remember a colleague telling me he was working on a case and had his papers on the floor, United States versus John Smith, and his son said, "What is this?" And he said, "That's the case." And he said, "The whole country is against you?" And the dad said, "Sort of." And it's really about sort of leveling the playing field. And one of the things I'm really interested in is this open file discovery that you referenced that the state of Texas does. I think Ms. Hensley has said, "Oh, that's not workable." Would you just speak a little bit about how well that has worked in Texas and what it actually entails?
I really welcome somebody to come there. It has been unbelievable. All the prosecutors, they're my witnesses, and Republicans who say this has really worked, and they have put it online. So, the case comes in and there are provisions made to make sure that information that everybody agrees should be redacted because it would endanger lives or invade people's privacy are redacted. But then it goes online and everybody gets to look at it. Because as Mr. Khan said, we just can't depend on prosecutors themselves, particularly in federal cases with all this information. No one prosecutor or even group of them is going to be able to go through all that data the way that a defense lawyer would to find out what's really relevant and really is information that tends to negate guilt or mitigate the offense. But when you have this open file system where you can actually see what was disclosed, when it was disclosed, no disputes, and most importantly, you really have to look at the Texas statute. I cited it specifically in my testimony, that at the time of the plea, everybody is sitting there, you know exactly what has been disclosed. The prosecutor is asserting all exculpatory information has been provided, and then the plea goes down. Because I must tell you, with all the innocence work we've been doing across the country, when the registry put out that 20% of people are pleading guilty to crimes they didn't commit, that's what the exoneration data shows. That means something. That's why we have to have pre-plea disclosure.
One of the other things that I know from my own practice is, when you sit through an arraignment calendar, you see lots of people, people of color, white folks. And then when you go to the prison and do your prison visits, it feels like the white folks have all been weeded out. And so this disparity in who gets held both pre-trial and post-conviction is an issue, I think, a very serious one. And I'm just wondering, when you think about pretrial detention and the impact it has on the ability of that defendant to prepare for trial, to help locate witnesses, all the difficulties, what kinds of reforms should we be thinking about to ensure that people are not disadvantaged from their ability to actually help prepare their defense because of their economic status, their inability to post bail? And secondly, this other question about the charging decisions by prosecutors who can by themselves decide whether or not someone will face the mandatory minimum or not. And then you run into these impossible situations in which innocent people say, "I want to plead guilty because I can get out to a lesser included offense, even though I didn't do it. Otherwise, I have to sit in trial as an innocent person awaiting my trial." So just in those two areas, what kinds of recommendations would you make for the committee?
Well, I think personally that the federal government has to step up. We need a Marshall Plan for indigent defense because it has been demonstrated. John Pfaff's book, Locked Up, we can show that so much more money has gone to assist prosecutors who are benefited in the state system because they do have police departments to work for them, right? Nothing can get somebody out of jail who should be out of jail pre-trial because they can raise money for bail if it's still a cash bail system, or they can put proof forward, or they can meet conditions of release. Then a good lawyer, and a lawyer from a holistic defense system that's rooted in the community, that is the best thing. And this study, I can't say it enough times, in the Harvard Law Review from the Quattrone Center, a 10-year study where they show that holistic representation compared to traditional representation dramatically reduced custody, particularly in the area of pretrial release. It's far better representation. It's good for the community. It increases community safety. It's where you ought to put your money.
Thank you. And with that, Madam Chair, I yield back.
I thank the gentleman for his questions, and I thank you for raising the issue of the law enforcement and the misrepresentation in some forms of pretrial work. I want to make sure that everyone knows that not one single member on this committee ignores the impact on victims and many families that are impacted. But I think we can work on those issues, Mr. Cicilline. I understand we are moving on that legislation. As we are looking to protect our victims, we want to make sure, as I said, that we emphasize justice. So thank you so very much for your questioning. And I want to check with Mr. Biggs. Mr. Biggs, do you have a witness, a member at this time?
It's my understanding that you've gone through all the Republican witnesses, Madam Chair.
All right, thank you so very much. Mr. Liu, you're recognized for 5 minutes.
Thank you, Chairwoman Jackson Lee, for holding this important hearing. Before I ask my questions, I want to make a statement about the radical voter suppression law that Republicans in Georgia enacted yesterday. Voting is one of the strongest expressions of our voice, of our opinions, of our beliefs. And when Republicans enact voter suppression laws, they are canceling the voices of many voters. So if you're a Republican who supports a radical Georgia voter suppression law, don't ever lecture anyone on cancer culture ever again. In fact, that law is so extreme, it criminalizes giving water to voters in line. If freedom means anything, it means we should be able to give water to another human being. And if you're a Republican who supports the radical Georgia voter suppression law, don't ever lecture anyone on freedom ever again. Now I'd like to talk about bail reform. On any given day, hundreds of thousands of Americans are sitting in jails, not because they've been convicted of anything, but because they can't pay the fee to leave jail. It's un-American, it has a disproportionate effect on the poor and people of color, and it's perverse because it ends up causing people to plead guilty at much higher rates. And my first question goes to Mr. Scheck. Thank you, first of all, for your work on Innocence Project. The people who can't pay this fee to leave jail, it would seem like they're the same kinds of folks that will lose their job, can't handle healthcare expenses, have a whole cascade of rippling effects. And you had a pretty stunning statistic that showed about 20% of people plead guilty to crimes they did not commit. Do you believe the cash money bail system contributes to that?
There's no question about it, and which is not to say that there aren't things that can be done to improve the release system to prevent some of the terrible things that we've heard about today. But the bottom line is the cash bail system has penalized poverty. I mean, if you're a poor person who can't make cash bail, or you have to get out to keep your job, it's logical that you will plead guilty. It's logical to plead guilty to get out. It goes way, way back. The process is the punishment. Malcolm McFeely's, great book about this. We've known about this for decades, but we're now becoming, thankfully, in this era, far more cognizant of the fact that race and class has everything to do with this, and we can stop it. And what Mr. Massey was talking about in his particular system just illustrates it. We can't run a system where we're inducing guilty pleas all the time to make the system work. And the way we induce it is we keep people in jail who just can't afford to pay bail. And there's so many good ways to change that. As I pointed out, the holistic representation and just changing the way we look at public safety can do so much for that.
Thank you, Mr. Scheck. I have introduced the Pretrial Integrity and Safety Act along with Chairman Nadler, and it provides grants to assist local jurisdictions to move away from the money bail system into a better system, such as, for example, the system that Kentucky has or Washington, D.C., and so on. And so I have a question for Mr. Khan. First of all, thank you for your service as public defender. Do you believe that freedom and liberty should ever be linked to how much money you have in a bank account so that you can pay a fee to leave jail?
Well, thank you for the question. I think the answer is certainly not. And I think that it's important to understand that not only is this devastating to the people who are kept in jail and who have no opportunity to return to their lives, and how destructive that is, how they lose their jobs, they lose their apartments, they lose their cars, and can never reclaim their lives, even if they're innocent. But it's also devastating to the communities in which they live, and it can be devastating in other ways. That when a cash system is in place, it's not only that the innocent get held, it's that oftentimes people who are truly dangerous, simply because they have the money, sometimes from criminal enterprises, to pay a bail bondsman, a corporate bail bondsman, can be free and be out on the street, rather than having some real look at whether or not people need to be detained. I'd like to point to one other aspect of this, of the way in which money affects people and affects their inability to contest their cases. You talk about innocent people pleading guilty, and I think one of the reasons that we haven't touched upon is the sense of hopelessness that a defendant in prison, pretrial detention, feels when they realize that their lawyer is so overworked and underfunded that there's no possibility of that lawyer investigating and contesting their case. And that's why Congress should act not only to encourage adequate funding for state defender systems, but also should look at an independent and adequately funded federal defender system. The Cardone Committee of the Judicial Conference issued a report calling for such a system in the federal system, and Congress needs to look at that and address that and move forward with it. That's another way to prevent innocent people from pleading guilty in this system.
Thank you. I yield back.
Thank you. The gentleman yields back. The gentleman's time has expired. Let me now yield to Mr. Biggs.
Yes, Madam Chair.
I have a member who is requesting 2 minutes, not myself. The two of us will conclude. I don't know if you have another member here, but without objection, I'm prepared to yield to her. But I want to be fair and don't know if you have another individual that likewise would use 2 minutes.
Madam Chair, I still have a couple of members on. I will check with them, but I feel free to go ahead and give those 2 additional minutes, and I'll ask my members.
Thank you so very much. That excludes you. I understand you have some information you want to share. That excludes.
Yes, thank you.
Thank you. Now, let me. I'm happy to yield to Ms. Scanlon for 2 minutes. As I do that, thank Mr. Lou for his testimony, and just want to make sure, Mr. Correa. Ms. Scanlon, you're recognized for 2 minutes.
Thank you. There was just one more issue I wanted to speak to. We talked a little bit about the fact that, juveniles are at this disadvantage given their development, et cetera, during pretrial. So they're more likely to plead guilty. They're more likely to make a false confession in many circumstances. And then when they're incarcerated, they're more likely to be abused statistically than adults, and less likely to be able to navigate the jurisdictional hurdles to being able to get relief. So one of the things that I've been working on is a bill called the Justice for Juveniles Act, for which we had bipartisan sponsorship, that would exempt juveniles from the administrative remedies portion of the Prison Reform Litigation Act. So, Ms. Camara, could you speak to how that might benefit juveniles going forward?
Absolutely. I think you raise a very important question about the susceptibility of children, because that's who they are. They are children to abuse when they're in juvenile detention facilities. I would point to DC Public Defender Service as a national model where you actually have public defenders embedded within juvenile detention facilities. PDS has an office where children can reach out confidentially to raise issues concerning confinement, but also advocate for the issues that arise concerning their release, whether or not they're properly programming and receiving credit for rehabilitation, which ultimately impacts when they're able to return home to the community. So I would definitely point to the DC Public Defender Service Juvenile Reentry Program as a national model that should exist in every state. Children's rights must be protected, and we have to invest in making sure that they are not abused when they're in those detention facilities.
Thank you for that, and I appreciate that as we move forward and try to find better models. Thank you, and I yield back. Thank you for everyone's courtesies.
Well, thank you, Congressman Scanlon. I want you to know this committee is particularly interested in juvenile justice. We thank you for that initiative, and we'll be turning our attention to juveniles in the justice system. And I think all of this will be more than appropriate. So we thank you for your line of questioning and for your leadership. Your time has expired. Let me now yield to Mr. Biggs. Mr. Biggs, is there anyone that is requesting a moment? Mr. Biggs?
Madam Chair, thank you. Of our members who are still on, so far as I can see, I'm just getting mentioned. No one has requested additional time.
All right, Mr. Biggs, I'm going to yield to you for 5 minutes. I need to take a clarifying 5 minutes, not to be considered a second round. I want to be able to thank our members and the witnesses, but I'm going to yield to you. I think for the record, we want to clarify that Ms. Bass was kind enough to yield to me for a moment, but we left when we finally concluded 3 minutes on the clock. So I wanted to make sure you had a time as we conclude this hearing. And I want to be able to make time to thank all the witnesses, but I do have 2 questions that I have. So I'm going to put 5 minutes on the clock for you, Mr. Biggs. And if you have submission to the record or any other matters, please, you are yielded to at this time. And thank you very much for your participation in the hearing. Thank you.
Thank you, Madam Chair. And I appreciate that. And I do want to thank all of our witnesses. It's been very informative. This has been a very important hearing, I think. And I thank all the members who've also participated. And so I want to go to Ms. Rogers, if I can, just because I had some questions for you that I had not been able to ask because I ran out of time, because that happens the way that goes. And I know that Mr. Graves, particularly thank you for your testimony as well. Both of you, very, very difficult circumstances and coming forward and testifying today. I'm very, very appreciative. And Ms. Rogers, I wanted to know if anyone in New Jersey had been held accountable for the clearly faulty risk assessment that led to your son Christian's murder.
Not at all. Not at all. As I stated before, there was a person, a politician, that referred to my son as being collateral damage, and it's the same all over the state with all the victims of this bail reform, and all we hear is how successful it is, but no one is considering us, and the things that we have to go through. And then, they're talking about, oh, bail reform's a good thing, and people are getting speedy trials and less detainment and everything, but it's been 4 years since this happened to my son, and we're still waiting on a trial. So, to me, it's a total nightmare. And the only thing that I'm asking is that they go back to the drawing board on some of these things, because it really wasn't fair the way they implemented it anyway, because they never informed us of the ins and outs of this thing. They just said, here, we're adapting this new law, and you all are just going to have to swallow it. They did not consider us in these neighborhoods. And, there's a lot of people are saying, oh, well, it's not fair to the people that are accused of these crimes. I'm not saying that everyone with misdemeanors and first time offenders or whatever should be held without bond and go through all of this. I'm talking about the people with the bad history, the terrible offenders and things of that nature. And my main objective is to have our neighborhoods be safe. I have grandchildren that can't go to our city park because of this mess, and I'm sick of going to funerals of people that I know who have lost people because of this bad reform. And this is my thing. Everybody's talking about cost and money and this and that. How much is too much when you're losing lives? And, I don't know. And my thing is, we should come together as a people to figure out this thing. Because it was done recklessly, I think. And it's not fair to us.
Well, Ms. Rogers, I really appreciate your taking testimony, coming in and giving testimony today. Very, very appreciative. I know it's got to be difficult, but I'm grateful. And I'm grateful to all the witnesses, again, for being here today. And with that, Madam Chair, thank you for the additional time, and I'll yield back to you.
Thank you very much, Mr. Biggs. I just want to make sure, did you have any documents you wanted to submit into the record?
Madam Chair, I submitted the one in my opening statement, and hopefully we'll get that to you digitally.
Thank you so very much.
Thank you.
I too wanted to utilize a brief time to ask two more quick questions, but also to incorporate my thanks to all of the members, and I will do so by acknowledging all of them and to give some final data that I think is extremely important. So let me quickly go to Mr. Scheck and indicate and build on Congresswoman Scanlon's line of questioning. Juvenile suspects, as well as adults with mental health problems or intellectual disabilities, are at heightened risk of a police-induced false confession. It's an empirical fact too that they often fail to comprehend and routinely waive their Miranda rights. What measures do federal law enforcement agents take to protect these highly vulnerable individuals during an interrogation and ensure that they're not coerced, tricked, or otherwise induced into giving a false confession? That's for you, Mr. Scheck.
Yes, again, that is special care must be taken and training when you're dealing with an intellectually disabled person. We at the Innocence Project are still dealing with the case of Purvis Payne, who's on death row in Tennessee, which is really one of the great travesties in terms of intellectually disabled person who is in exactly the position you just discussed. But again, I think the best thing is recording the interrogations. It's very important that you put into the federal rules of evidence the idea that a confession the issue of reliability should be considered when you're looking at a confession, because so many intellectually disabled people, or anybody that's in a position where they're being coerced and they give a confession, the only thing the Supreme Court looks at in Colorado versus Connolly is voluntariness. And it only makes sense that you should also consider the issue of reliability. All the experts into interrogations always agree. They look to see, is this information that only the real perpetrator of the police would know? Did this lead us to other incriminating evidence? That is the reliability test, and that should be put into the law.
Thank you so very much. Mr. Khan, I could not finish with you, and quickly would you respond to this question? Evidence shows that lying informants and cooperators are responsible for a sizable percentage of the wrongful convictions in this country. The reliability of informants poses serious systemic concerns. You started to answer, but what are the most pressing problems involving law enforcement's use of informants in federal cases, and how can we best address them? And I'm saddened that your time is short because I have to conclude with some other comments. But Mr. Khan, would you please try to give me a response to that, please?
Let me try and be very brief. First, I think that Congress needs to look seriously at the rewards that can be offered informants and prosecutors' unilateral power to offer those rewards. The other suggestion I'd make, practical suggestion, is that evidence about informers needs to be turned over early so that the defense can investigate. It's only when there's adequate time to investigate these informants that there's an opportunity to learn what their true motives are, what their true role in the crimes are, and to expose that when necessary to a jury. So I think that's an essential element of ensuring fairness in our system. Thank you.
Thank you very much for providing that insight. I think that's an area that needs to be assessed. And of course, we need to make sure that we are fair to all. Let me start out. First of all with my appreciation to all of the witnesses. And as all the witnesses have done, I want to acknowledge Ms. Rogers and her pain. It is not gone ignored. And this committee believes in justice. And we are as much concerned about those who are victims as we are concerned about those who are victims in the justice system. So again, we want to express our appreciation to the witnesses that include, of course, Mr. Scheck, Ms. Daria, Ms. April Frazier Kamara, Mr. Reuben Khan. Believe that we've called off all of our witnesses, and we want to make sure that we express our appreciation for all of you for your presence here today. I think it is also important, Ms. Hansley, of course, and Ms. Rogers. It is also important to make sure that the record is clear, and there was testimony or statement that I believe should be adjusted, or at least there should be something in the record. Allow me to indicate the following information very quickly that needs to be included. This data is somewhat listed as the most recent data, but it is 2013. Black juveniles were more than 4 times as likely to be committed as white juveniles. American Indian juveniles were more likely than 3 times as likely, and Hispanic juveniles were 61% more likely. We do know that this issue of committing juveniles, and as well not having access in the pretrial or the preliminary stages, can be very devastating to young people, and it falls heavily on minority youth. Let me say to Mr. Graves, who I've had the privilege of knowing as I conclude, what happened to you has happened tragically to many in an unfair justice system. And I think what is most explicit in your testimony is that you are open in your responses to all those who question you, and all you wanted to do is press your innocence. And of course, the tape that was utilized in your knowledge and your understanding was never provided to show your innocence, and your guilt seemed to rely on someone who called your name. whether as an informant or alleged co-defendant, you were unjustly prosecuted. I think that's an important point that we need to make. So let me, as I conclude this hearing, again, acknowledge all the members that participated. I think it is appropriate to indicate that justice requires a response to those who are victims. In most instances, that involves those who are falsely accused, and that involves those, Ms. Rogers, who have suffered. Our greatest sympathy to you. I conclude in this hearing to acknowledge the killings in Atlanta, where 8 victims' lives were taken. 6 of those were Asian Americans. It requires this nation to bring the perpetrator to justice, that justice be rendered to them, and as well to acknowledge those victims in Colorado, which included a law enforcement officer. We mourn with their families, and of course, justice must be brought to them. This committee is a committee that believes that justice is one that we must fight for and we must render. So this concludes today's hearing. We thank all of you for your participation, members and witnesses alike, and I thank you for the commitment that you've made to present your facts and your testimony to the United States Congress. You're truly distinguished, and we thank you for your attendance and participation. Without objection, all members will have 5 legislative days to submit additional written questions for the witness or additional materials for the record. With that, I would call this hearing is now adjourned. Thank you all so very, very much.